Should we open the light?
Okay. Welcome, everyone. It's with great pleasure we welcome Penny Clark this morning. And as we get started, we also welcome Pastor David, who will start us with prayer.
Just grateful for this day. Lord, we give you thanks for the gift of heart and mind to live our faith out in the world. In gratitude for Penny and for her wisdom and experience and willingness to share her insights with us, we are grateful for the world that you've made and loved and redeemed through Christ at time, and for the opportunity for us to play a part, however small, in healing of the world. We ask for that opportunity and guidance. For this time we have together, we lift up our gratitude in Christ, in whose name we pray. Amen.
Thank you.
Thank you.
Well, we didn't really intend for this morning to be quite the same morning that followed 2 weeks of talking about holy war. But we really are very grateful to have Penny Clark with us this morning to address some of the challenges that we're facing to the court system. Longtime member and major contributor in so many aspects to Bradley Hills. We welcome you, Penny. Thank you. The time that you are giving us the expertise. Before I go any farther, could you please mute yourself? There are some folks that are need to. We do hear you, so I'm going to stop the introduction just so that we don't have any more. We're sure that we can hear about this. Okay, thank you. At any rate, yes, Penny. Penny's background is 44 years, including arguing employee benefits cases before the Supreme Court. She was a law clerk to Associate Justice Lewis Powell Jr. of the Supreme Court from 1974 to 75, one of the first dozen women to ever clerk at the U.S. Supreme Court. She has a superb, very valued career and many insights that she will share with us. And I won't, I'm not worthy of taking her time. This morning, I'm just so glad to have you with us. Thank you, Penny.
Thank you, Carol. So I thought we'd start with a very quick refresher on what the federal court system is for those of you who didn't have legal training. There's a diagram that Carol's going to put off. It's greatly simplified because I just wanted to focus on what you're hearing in the news these days. So there's 3 levels. The cases, the district courts, well, no, it's not up there yet. Okay.
Just 1 minute.
Okay, so the U.S. district courts are the level where most cases start. And that's where you see trials with juries and witnesses and the like. Usually a case will go all the way to a final judgment there before there's an appeal to a federal court of appeal. There are 13 federal courts of appeals. And 12 of them are generalized. 1 is a specialized court. Usually, again, the case goes all the way to final judgment at that level before there's an appeal to the Supreme Court, which is the highest court. And the final word, other than Congress can amend statutes if that's what the court makes its decision on, or the Constitution can be amended in theory. It hasn't been done since 1992. Putting aside the Equal Rights Amendment and all the issues related to that, but and as you can well imagine right now, if anything is partisan or highly controversial, that they're not going to get the supermajority of states to ratify any kind of constitutional amendment. So that's kind of a long shot at this point. The Supreme Court does not have to take every case that comes to it. There are a handful of cases where there is a right of appeal to the Supreme Court, but they're very, very rare. Most go up to the Supreme Court on what's called certiorari. And the court has the discretion to decide whether it's going to take a particular case. And in fact, it takes a very small percentage of the cases on which somebody petitions. The latest number I've seen is about 4% of cases where the party petitioning is represented by a lawyer. There are lots more cases that come up by people who aren't represented by lawyers, many of them prisoners. Those are almost never taken. So if you took the whole body, it's probably less than 1%. Now, things sometimes accelerate. So you see, okay, so the green is the usual district courts, courts of appeals. The yellow is the specialized court of appeals for the federal circuit. And then there's a U.S. Court of Appeals for the Armed Forces, which is not much involved in the cases that we're hearing these days. Now, when there's something that's thought of as an emergency situation, so that's usually something that could happen while the case is pending, which can be several years in the normal course. I mean, this is not a system that's designed typically for things to happen fast. So if something might happen that can't be rectified by a damages award, you can't solve it just by awarding money to the party that wins in the final end of it, then that party can petition or move for what's called an injunction. There are preliminary injunctions which get entered while a case is pending and are only good until the end of the case. There are permanent injunctions which get entered at the very end of a case to the winning party sometimes. Now, the whole idea of these injunctions is that they're supposed to kind of preserve the situation as it existed before the lawsuit was filed, or the situation as it existed before somebody did something bad to somebody else, called the status quo. They're trying to preserve, that's a Latin term, the status quo. Sometimes a court of appeals will jump in and issue a stay of an injunction that the district court has entered. Sometimes the Supreme Court will jump in and issue a stay of an injunction that the Court of Appeals has already affirmed. In increasing numbers in the last few years, the Supreme Court has been jumping in with stays of injunctions from lower courts before a case can be completely briefed, before they've even decided whether they're going to take the case on the merits. This has come to be called the Supreme Court's shadow docket. The Supreme Court pushes back on the use of that term because it sounds kind of nefarious, but many people call it the shadow docket, and they usually make those decisions with very little briefing, often without, most of the time, without an argument before the court. And they can be rushed. I mean, one of the shadow docket orders that has came out at midnight one night. Now, you know, you've seen in the news, often these are real emergencies, like somebody's about to be executed in a state that has the death penalty, and the Supreme Court is asked to step in at the last minute. But the others that have been really fast in this year, this very unusual year, have been deportation cases. There have been a couple where the Supreme Court has stepped in at the very last minute to prevent a deportation. As you can see, I mean, this system is not designed to deal with a president who comes into office with the thought that he's gonna dismantle, demolish most of the federal government, that he's gonna shake things up, that he's going to create chaos, that somehow shows strength. I mean, you could imagine, and I'm not going to accuse anybody, but you could imagine that the president who's been advised about how this system works and how it tends to be sort of slow and clunky would think, okay, I'll just throw everything I've got at them and let them stop me. I mean, just let's see how many things they can stop. And sooner or later, yeah, okay, the courts of appeals are gonna stop me, maybe the Supreme Court, but it's my Supreme Court. I put a whole bunch of justices on there. You know, you can readily imagine that the president has the view that he wins one way or another. And now, so what has happened since Trump was inaugurated the second time? There have been more than 650 cases filed against the administration, according to the New York Times count. Now, I gave you in the handout on the back of that at the bottom, there's several different websites that are tracking what's going on. And if you're curious, you can follow them. That first one, the New York Times tracker, purports to list all of the cases, other than the 2,000 cases that have been filed to get tariff refunds in the last 10 days. So, I mean, those they're not even trying to keep track of, but there've been, they say, more than 650 cases. I think there are some they're not counting. I think the number's actually larger, but I haven't tried to figure that out. I mean, I've read enough from the 650 cases. According to, I mean, a few of these have reached final judgment in a court of appeals, not many. A more significant number have now reached final judgment in the district courts and are working their way up. Only one case has gone to final judgment in the Supreme Court, and that's the tariffs case that was decided Friday a week ago. According to the Brennan Center of Justice, another tracker, which only is tracking the shadow docket in the Supreme Court, the Supreme Court has issued 25 decisions on the shadow docket. 20 ruled for the administration, at least partially, and 5 ruled entirely against the administration. 4 of those, of course, were just temporary interim orders, because we only have the one final order in the tariffs case. The New York Times says of the 136 cases now have a final decision, either at a district court level or Court of Appeals. 51 of those were decided for the plaintiffs. 6 were decided for the Trump administration, and 2 have what they call a mixed outcome. So the plaintiffs won on some issues, the Trump administration won on others. So the ones in which the Supreme Court has ruled against the administration on stay applications are deportation cases, which I mentioned a minute ago. In 2 cases, Abreu Garcia, and a case that came up under initials AARP, not the organization you're familiar with, but some immigrant. They ordered the Trump administration not to deport somebody, or in the case of Abreu Garcia, to facilitate his return to the United States. The other 2, one is Illinois versus Trump, which was also decided pretty recently against the use of National Guard, federalized National Guard in Chicago. And then there's one other, which you've probably not heard of, Margolin versus the National Association of Immigration Judges, where the Supreme Court denied a stay of an order where somebody had said, all those immigration judges that you fired, the Trump administration was arguing, oh, let them take their case, their individual claims to an agency that's designed for immigration judges to appeal their dismissals in, kind of routine cases. Somebody's dismissed for incompetence or misbehavior or whatever, but let them take it to that. Well, what the Trump administration wanted them not to notice was that those agencies have been essentially dismantled. So there's really no place for these judges to go other than the federal district courts. And the Supreme Court actually denied a stay in that case. So they've said that the immigration judges can go through the regular court system, at least temporarily. So, I think it's still early despite the fact that it's been a year that we've been suffering under this. But, and things could shift, but I'm seeing what I think are three major themes emerging from the cases that have been decided. One of them limits the president's power, one limits Congress's power, and the other one limits the courts. So starting with the limit on the president, and that comes out of the tariffs case. The Supreme Court, you know, in the last 5-6 years, I'm guessing, I haven't really tracked it back to its origin, has started with this thing they call the major questions doctrine. And they say, okay, if we think something's a really major question, I don't think they've yet defined how you decide that. And frankly, there's a lot of room for judgment about what is and isn't a major question. But if we, the Supreme Court, think that something's a really major question, we're going to decide, we're going to say that the president can't claim that Congress has delegated authority to him to act unless Congress has been explicit. So, for instance, they applied that in to keep Joe Biden from forgiving a lot of student loan debt. That was to them a major question. And now, according to 4 members of the Supreme Court, that's a major, the tariffs are a major question. Now that one I can accept. Tariffs sound like a major question. For one thing, Congress, under our Constitution, has the authority to tax, and a tariff is a tax. And that's the basis on which the majority of the Supreme Court ruled against Trump in the tariffs case, is that the statute that was involved, the International Emergency Economic Powers Act, known as EPA for short, did not specifically say that the president could tax imports coming from other countries. And because the president doesn't have the authority to tax, only Congress has the authority to tax, the statute just doesn't give the president the authority that he claimed to just willy-nilly impose a tariff and say the next day, no, wait, I don't mean 10%, I mean 15%. No, let's take it back. It's a 5% tariff, you know. Congress, the statute, the International Emergency Economics Powers Act, according to a majority of the Supreme Court, can't reasonably be interpreted to give the president the authority to impose those taxes. Now, as I say, 4 members of the Supreme Court would apply the major questions doctrine as well, but they're a minority in that case. And then, 2, Thomas and Alito, have argued, Thomas Alito and Kavanaugh, so 3 argue that the major questions doctrine shouldn't be applied here. And they want to carve a few things out. Well, if it has something to do with foreign policy, according to Thomas, no, so let me get this right, Kavanaugh, according to Kavanaugh, it's because it's foreign policy. And he thought the statute was sufficiently clear that you could read it to give the president the power to tax. Thomas wrote one in which he says major questions should only apply to core legislative powers. Okay, so what's a core legislative power? Well, that's
levy tariffs.
Well, apparently not. The power to make substantive rules about deprivations of life, liberty, and property. Now, Gorsuch wrote a really interesting long opinion in which he criticized every other group of the court in how they would apply the major questions doctrine. But he is firmly in in the camp of saying the major questions doctrine applies here and limits the president's authority. So, yeah, sure, Steve.
IEPA is an incredibly broad statute.
Mhm.
I used to do counterterrorism finance at the State Department. And IEPA was the vehicle that we used to levy sanctions and freeze financial assets of terrorist groups.
Mm.
That was never in question. That was never considered to be a,
Mhm.
a major question.
Well, it wasn't a tariff for one thing.
Yeah, it wasn't a tariff.
Yeah.
It was certainly affected the whole world financial system because any banking institution that had assets in the United States was obligated to follow this.
Mhm.
And every international bank has assets in the United States,
Sure.
or their assets flow through the United States.
Mhm. No, it's a legitimate statute,
Yeah,
and it
yeah.
certainly gives the president a lot of authority, but to impose taxes or tariffs or duties or imposts or any of the long history of words that have been used to describe
We have
tariffs is not one of them.
Of these emergencies that have been declared simply by executive order.
Yeah, oh, yes, yes. And another one of the questions which you'll see in these cases is whether anybody can second guess the president when he declares an emergency. You know, so is it enough that the president says this is an emergency? As you know, I mean, Trump sees everything's an emergency because he thinks that gives him power. But his lawyers are arguing in court over and over again under a whole bunch of different statutes. Well, when the president declares an emergency, that's the end of the matter. You don't get to decide whether you think that there's really an emergency or not. So far, the courts have not been willing to go that far. Okay, so that's the limit on the president, this whole major questions doctrine. Then there's a limit on Congress. This one is likely, we don't yet have the decision in the president's attempt to remove the heads of what we call independent regulatory agencies. To give you just a moment of history, you know, these, other than the Federal Reserve Board, which may be, and we hope is a special case, these independent regulatory agencies pretty much date back to the beginning of the 20th century, and then large numbers created from Franklin Delano Roosevelt's administration forward. And the idea is, in large part, things have gotten so complicated and so technical that it's unreasonable to expect Congress to enact all of the very detailed regulations that are needed to implement these statutes. Think Nuclear Regulatory Commission. Yeah, right. I mean, think Consumer Product Safety Commission, you know, Securities and Exchange Commission. There something like 16 of these agencies, some of which you've probably not heard of. But long ago, Congress decided, okay, we're not going to try to regulate all the details that need to be regulated for business to know what it should and shouldn't do. We're going to create these agencies, and we're going to provide that one president can't put the entire board on the agency, so that the agency's governing board is going to be staggered.
Excuse
and
me,
they're going to have terms.
May I ask a question? I'm sorry, this is John.
Sure.
Thank you. I have trouble with, quote, independent agencies. The Constitution establishes 3 branches of government. So are they, quote, independent agencies? Do they not really have to be under the executive?
That's the issue.
That's the issue.
That's
the chief
totally
I
the
mean,
issue.
I mean, we don't
Yes.
have a 4th.
That's
arm
the
of
issue.
government. Thank you, ma'am.
Okay. Nope. So, you know, the idea was that these boards then, superintendent agency, which both defines all of the details that the law is going to require people to follow or going to prohibit, and then they're going to enforce those. And ultimately, their decisions get appealed to the courts in very large numbers. So the theory that the president is asserting, and that's been developed by conservative lawyers over the last, probably 20 to 30 years, as they've begun to, they don't like the regulatory state. They don't want all of this, in part, the people who don't like the federal government are pushing this theory. In part, it's a concern, as John articulated, that, where does this fit in a government of three branches created by the Constitution? And there are those who point to the language in the Constitution, which says the executive power of the United States shall be vested in the President of the United States. So they say, well, this is executive power, and therefore it belongs to the president. So Trump has asserted that he, as the unitary executive under this theory of the reading of the Constitution, has the authority to remove the heads of the so-called independent regulatory agencies at will, just because they don't agree with him. Yes, Steve?
Let me clarify something. So it's the president generally, and I take the NRC, my former agency, as an example. The president always has the sole power to designate the person as the chair, or in effect, the head. But on the multi-member agencies, you have, for example, the NRC has 5 members.
Typically,
no more than 3 can be a member of the same political party.
Right.
So you could have 3 Rs under a Republican president. I was an independent, and I was tempted to declare myself a Republican, so he could not appoint. He would have to appoint a Democrat. But all the facetiousness aside, what he's done in a number of cases, and he did it at the NRC, is he removed who was the former chairman, who he had replaced on January 20th of 2025. That person was still on the commission because his term continued. In fact, it was the longest term until the end of 2029. And Trump removed him. And that's what he's done in a number of places. And I know that I think the case is one of the FTC cases. But that's what he winds up doing, because he generally has the power, I think, to designate the head of the agency.
Yes.
But it's this removal without cause that goes back to a 90-year-old precedent, Humphrey's executor, which is dying, in my view, given what
it seems likely, yeah.
And it was Franklin Roosevelt, of all people, who fired an FTC commissioner, and the court said back in the 30s, no, you can't do that because you have the for-cause approval. And I would also point out, even with the NRC, which is only 50 years old, was preceded by the Atomic Energy Commission in the late 40s, late 40s. And it had the same for-cause removal provisions that was extended when the NRC was created.
Right. No, that's a good summary, and thank you for pointing that out. That the boards typically have an odd number of members. The president is in a position to put the majority in of his party and to nominate the chairman, but the terms are staggered, and the idea under the statutes is that people on these boards can only be removed for misconduct or malfeasance in office or something like that. So what seems likely from the arguments that have been held in the Supreme Court on the removal of I think the one that they argued is Slaughter, plus the Federal Reserve Board, which is, as I say, may be treated as a separate and different matter, given its history. The argument is, I'm the president, I can remove as many people as I want, whenever I want, I can put my people in so that I'm entitled to have complete control of these agencies. Yeah.
Does that also apply to the inspector generals? Is he also asserting that power to remove those inspectors?
Well, I think Yeah, I think the inspector generals that he has removed have been in the agencies that are unquestionably under his control, executive agencies. But that's a different issue, and that's a good one to point out. I mean, there is,
Because he's done that.
he has done that, yes. So that's developing and seems very likely to end up with a reversal of this 1935 case called Humphrey's Executor, and a ruling that the president can remove these independent agency board members whenever he wants to.
Just to put a gloss on that,
Mhm.
the reason that matters is that Congress, to your point, designed these agencies to have a structure that would not be so beholden to one political party or one president. So that's why they're referred to as independent, and that's why the structure being changed would make them no longer independent. So it would really undermine the statute and would say the president has the power to do this. Congress cannot alter that power by creating a structure of an independent agency in this way. And you see it more in the press around the Fed, because the Fed's independence and the need for that independence is very much, there's a consensus of sorts around that. It's less obvious because people don't think every day about whether it's really important or not important to have an independent nuclear regulatory commission, but you might see reasons for that.
Sure,
So-
no, I mean, and indeed,
Those are the states.
if we had a Congress that was inclined to assert its authority, they might well say, well, okay, so we just need to ramp up our staff and put a lot of experts on staff who can legislate or advise us to legislate about nuclear regulation, about environmental safety. Again, you can make a long list. What's most important to Congress in that area? At the moment, Congress isn't going to do anything. You can be sure of that. As long as the majority is agreeing with almost anything the president
And you might give
throws at them.
less discretion to those independent agencies if you knew that they could use their law enforcement and other kinds of powers in partisan ways.
That's right.
Yeah.
So then the third theme well, it's already emerged, is limits on the court's power. Think back to, the term is universal injunctions. So the idea is, an injunction issued by one lower court that applies nationwide, applies to everybody. Think back to the Biden administration, when there was a judge in the Western District of Texas, Kaczmarek. I think he was the only judge in that district. He was very conservative. So if you wanted to overturn something that the Biden administration was doing, you find an excuse to sue in his district. You know he's going to be assigned to the case. He issues an injunction that stops something nationwide. Abortion medication. I think that was his decision. There were a variety of things that he did. Most of us didn't really think that was a good idea. But now what the Supreme Court has held is that in no case, with two exceptions, which I'll mention in a moment, in no case can a federal district court or a federal court of appeals issue an injunction that applies to everybody all over the country. They've said when the birthright citizenship case came to them for the first time, they didn't decide it on the merits. They just said, we're reversing this universal injunction, which was entered below, because the statute, which gives the courts authority, doesn't give them authority to issue this kind of injunction. We can't find a parallel authority in the Judiciary Act of 1789, and therefore the federal courts don't have that authority. the two possible exceptions, which the court kind of, carved out in footnotes, basically. Although I think these are gonna hold up because they really have to, is what we call a class action, which is, so I'm affected by something. I think that there are thousands of other people who are affected by it, or maybe even just dozens, but enough that you don't want each one of them individually filing a lawsuit. And I come into court and I say, please give me status as a class representative and decide this case on behalf of my class. So class actions are established in the federal rules of civil procedure. They've been around in one form or another for a long time. And I think they're going to hold up. But of course, they don't always apply. So it's not always the case that you can find a reason for a class in a lawsuit that might otherwise be a nationwide injunction. The other possible exception and likely exception is the Administrative Procedure Act, which says that a plaintiff can file a lawsuit involving a federal agency action and can set it aside if it's against the law or against the Constitution or arbitrary and capricious. There's a list of reasons. Those are kind of the main ones. That one, so can Congress change this universal injunctions notion? Can they authorize universal injunctions by legislation? Probably is the answer. I mean, I could imagine at some point a very conservative Supreme Court, which we have, saying, well, no, if it wasn't in the Judiciary Act of 1789, we don't think that the Constitution, which gave the judicial power to the judicial branch, intended for a single court, other than the Supreme Court, to have that kind of nationwide authority. So that's what I am seeing as the limit on the courts, and we're going to see more litigation over that, you can be sure. So just to end with a quick summary.
I've got it.
Okay.
First, after she finishes.
Yeah, I'm gonna leave time for questions. So the topics on which the lower court rulings so far seem to strongly favor the plaintiffs. I've birthright citizenship, clearly every single court that has decided that has decided that the declaration that you've got to have a parent who's an American citizen in order for the citizenship clause of the 14th Amendment to apply to you has said no, no, no. So that's one. The retaliation against law firms and lawyers who either participated in Trump prosecutions before they joined the law firm, or the law firm has been not friendly to Trump's policies. Every one of those cases in the lower courts has gone in favor of the law firm, or in one case, an individual lawyer. There have been a handful of cases which have protected First Amendment freedoms of people demonstrating or protesting against ICE and the National Guard and the like. And while some of them are kind of detailed in saying what you can do, what you can't do, what tactics the Guard can use in countering demonstrations and the like, they have generally gone very favorably for the plaintiffs. An interesting one for this group, there have been 3 cases involving a change of policy by ICE in which it allows its officers to go into churches or other places of worship to arrest people they believe to be illegally in the country. 2 of those cases have ruled in favor of the plaintiffs. And those cases are pending on appeal. The one that went against the plaintiffs just said this particular church, the Mennonites, had not shown any reason to think that this policy was about to be applied in their congregation, and said that this is just, we're not ready to decide this case. So that one is an interesting one to follow. Grants, federal grants to institutions like medical schools, like colleges and universities, state agencies, and the like. As you may recall, the Trump administration has imposed all kinds of new conditions on existing grants. So they just swept in and they said, we're terminating all of these grants because either they say the indirect costs, which are being charged here for research, facility costs and administrative costs and all of, the building and all of the other things that are classified as indirect costs are going to be capped. And if you're over that cap, then your grant is terminated. Other grants have been terminated because the grantee wasn't willing to sign a piece of paper that said, we will follow all of Trump's executive orders, or we won't do any DEI, or we promise that we won't do anything to interfere with your enforcement against immigrants. All of these, which had nothing whatsoever to do with the grant or the topic of the grant. Those cases have overwhelmingly gone in favor of plaintiffs. At least as to existing grants. So, as to future grants, they're slightly different agencies, or issues. But the courts have generally said, we're just not going to let you sweep in and change the terms of existing grants. And these unrelated policies, we're really skeptical of the authority of the administration to do that. And this is somewhat surprising to me, environmental regulations, where the Trump administration has changed a lot of those. Those have generally gone in favor of plaintiffs. So again, early, there's a lot of cases left to litigate. And you can track them, or some of them at least, with the websites that I've identified there at the bottom of the handout.
Well, we have one question that was posted a long time ago. Sure. And Pat Stark wants you to speculate on what issues may affect stopping the midterm elections.
Let's start with an easy one.
And
let's start with an easy one, the elections. Well, there is a case pending in the Supreme Court already, scheduled for argument this month, Watson versus the Republican National Committee, which raises the question whether federal law prohibits the counting of ballots received after Election Day. So there are something like, 24 states, maybe half the states will allow a ballot mailed by Election Day, but received afterwards to be counted. And that issue is going to be decided. I think it's reasonable to assume it will be decided this term. And I don't have any insight on where that one's likely to go. The others, there's a case that was decided in the District of Columbia in April, against an executive order that ordered the Election Assistance Commission to amend the National Federal Voter Registration Form to require documentary proof of citizenship whenever you register to vote. And that can mean when you move from one precinct to another and you re-register in the new precinct. And has ordered federal agencies not to hand out voter registration forms without first assessing whether the person is a citizen. So there's a preliminary injunction issued against those two requirements. The administration, interestingly, didn't appeal from the preliminary injunction. But the final judgment was issued just a month ago. at the end of January, and the time for the government to appeal from that one has not yet run out. They have 60 days to appeal. So it will be interesting to see what happens. A preliminary injunction was also issued against that executive order in California. There's an appeal pending there. And then the redistricting, I mean, it was really interesting there. I mean, you may remember that there was an injunction issued against the Texas redistricting on the ground that the district court found that it was done in a racially discriminatory manner. A stay was entered, and the Supreme Court stayed that injunction, said no, the redistricting in Texas is valid for this election, essentially, go forward with it. Then, to my great relief, when the same issue came up from California, the Supreme Court denied a stay. And I mean, sorry, denied the stay. The lower court said, no, we're not going to stop the redistricting from taking effect. And the Supreme Court said, we're not going to interfere with that. So redistricting is what it is in California and Texas. And that's a nice, balanced result, since one side is Republican and the other side is Democrat. And I think you can reasonably assume that if they don't let the redistricting be stopped on the grounds of racial discrimination found by a district court, there's almost no ground on which they would stop that redistricting. So I think the redistricting, whatever gets passed in the legislatures and in the states, is going to stay in place for this midterm election. Can he stop the election from happening at all? Can he declare an emergency and invoke the Insurrection Act? I truly hope not. I hope that the courts would stop that. And again, going back to the question of, are the courts willing to say, we get to look behind his declaration of an emergency. We're not going to just say he's declared an emergency. Well, that's that. He has that authority. I think the courts are going to insist on their power to have some say in the matter. I hope.
Yes.
I'm not sure of the regulatory or the judicial court where this FISA court, how is that composed and where does that fit in? And is there any judgment that is the rulings, or how do you see what comes out of the FISA courts, the rulings that allow wiretapping for the use of AI in surveillance or things like that? I assume that all goes to the FISA court. Is that in jeopardy, or is that being bypassed just to, well, has that come before the Supreme Court?
It's certainly not come to the Supreme Court, and I haven't seen any litigation in the lower courts on that. So I apologize, but
They have
there's nothing I've seen.
in here, so if you know the answer, yeah.
Yes.
I have a very different question. And
Yeah.
You can take it now or later or whatever you want, but because we've talked a lot about today, I'm interested a little bit in the historical perspective. What was it like to clerk for Justice Powell? Do you have a favorite Justice Powell story? Did they treat each other differently back then?
Well, I of course don't have any insight into how they treat each other now. There were some very interesting cross political divide friendships. Justice Brennan and Justice Rehnquist were close friends. The two bills, and of course that carried through into fairly recent years with Justice Ginsburg and Justice Scalia, who were very close friends. But I think my favorite Justice Powell story, and I'll be very brief about it. Most of you have probably heard of the ultra secret in World War II. We broke the German codes. There was a whole group at Bletchley Park in England that was regularly receiving intelligence about what was going on and passing it along to the commanders in the field. Justice Powell was a liaison with the US Air Force for that operation. So he was fully aware of the ultra secret. He knew how important it was. And when a book was published during the year that I was a law clerk about the ultra secret, and it came out that he had been part of that, that was the first his wife knew about it. Now, you know, if you want, I mean, talk about integrity. He had been sworn to secrecy and he kept that secret. So that's my favorite Justice Powell story. But did anybody know anything about the Pfizer court or what's going on there?
A little bit. It's a court of very specific, very limited jurisdiction. Which only hears and doesn't really function like a court in that the government seeks permission from it to do something, whether it's to wiretap within the US, whether it's something else related to intelligence. I don't know what the appeals from it are, but this is a court that gives permission to the federal government, generally, I think exclusively the intelligence agencies, and mostly the NSA.
So have you heard of any cases coming up in the FISA court, or there is a FISA appeals court, which hears their
Yeah.
appeals? Has anybody heard of litigation in that area? Yeah, I don't know of any in this term.
Ben, did you have a question?
You mentioned Justice Powell and integrity. My question is, how much can we count on the Supreme Court members showing integrity in what they do, whether or not they come from a more conservative judicial belief system or not? I would like to believe that maybe 7 would have integrity, but
So would I.
I was disappointed in Kavanaugh's vote. Any insights as to that question?
You know, I like you, I hope that ultimately they will see the crucial importance of their role in preserving democracy, in preserving the powers of the other branches of government against the encroachments of the Trump administration. I will say, I enjoyed in reading the tariff opinions that the opinion for a portion of the majority opinion, but so this isn't speaking for a majority, this is speaking for Roberts, Gorsuch, and Barrett, all of which are on the conservative wing of the court, quoted something from the steel seizure cases during the Korean War that talked about the usurpation of congressional power by the president. And then in Gorsuch's separate opinion, he described the major questions doctrine as one that safeguards the assignment of lawmaking powers to Congress against executive encroachment. I mean, I found their willingness to use that kind of stern language pretty encouraging. And that adds up Roberts, Gorsuch, Barrett. Of course, then the 3 women who are liberals on the Supreme Court are going to agree with that point of view. Steve.
There's some here.
You got some questions?
Does the court look toward practical consequences of decisions? I know in Kavanaugh's dissent, he was worried about how do we get money back to people who paid the tariffs. In the birthright citizenship cases, banning universal injunctions essentially leaves us with a patchwork. If you are born in this jurisdiction where the court has decided that no, the president can't limit it, okay, you're a citizen. If it hasn't been addressed in the jurisdiction where you live, the president's executive order is still in effect, so no, you're not a citizen.
I would say the following, and maybe this is going to sound a little cynical. I think they pay careful attention to practical consequences when it tends in the direction they want it to. For example, you have a separate opinion by Justice Kavanaugh in a case involving whether ICE can stop people on the street and detain them because it thinks they might not be citizens or legally entitled to live here.
Killable reason.
In which he says, and of course, if they've got documentation that shows they're citizens, they'll be released promptly and there's no big problem. They go on about their business. Well, really? I mean, we're reading cases daily, weekly of people who are either citizens or lawful permanent residents who get seized, who get thrown into one of these detention facilities and held for a week or 2 weeks or longer before ICE finally accepts their documentation and lets them go. I'm cynical on that one. I think
We have one other question in the, or actual statement in the chat. Just a minute, sorry. Sorry, I'm just not as fast as I need to be. Hold on. Oh, Michael Gibson. Michael, maybe you can just tell us.
Yeah, just that appeals from the FISA court are heard by the FISA court of review, and appeals from that go to the Supreme Court. I just wanted to say one other thing, and that is that they are now referring to those as Kavanaugh stops.
Interesting.
I love it. Thank you.
Yeah.
For like one more question and then.
What's your view on the immunity?
The presidential immunity?
Yeah.
I haven't read it, mainly because I would find it too painful to read. I think that's about all I can reasonably say.
And you can see I was part of the former military group that filed an amicus saying this is terrible because it's not gonna be the president who pulls the trigger. It's gonna be a service member who pulls the trigger. And now you can see the jeopardy, what we believe is the jeopardy that these young people in, the Caribbean are being put in because they're being ordered to do things that is not clear or lawful.
Yeah.
Although on the other hand, the president has been pulling a few triggers too, so.
Yeah, well.
I don't know, yeah.
Practicality kind of issue, like there is sort of a thing about the Pandora's box or the cat's out of the bag already, where there are, I think, things that you can't really take back. So if he's keeping everything where the court has to go so slowly, but it's broken, or it was broken,
Right.
and it can't practically be fixed.
Well, that's right. And that's one of the concerns is, my 44 years in practice, I spent as an employment lawyer representing employees and unions. And I find it just appalling to read opinion after opinion that says, oh, well, we can remove employees and ultimately they'll get back pay if they were wrongly removed. Well, that might be 5 years from now. You're talking about disrupting somebody's life, taking away their income, the way they support their family, and then 5 years from now they get back pay, and everybody just kind of shrugs and says, "Oh, no big deal."
Yeah, and that's disruptive to that one.
Of course it is.
But how about if you go to war without Congress's approval?
Well,
that's broken.
Well, but I can't see any way practically that the courts can stop that. I mean, let's be realistic. The court isn't going to be able to say to the aircraft carrier, don't launch those aircraft. It's not going to be able to say to the destroyer, don't launch those missiles.
How do you, then say,
even Congress can't stop that in a realistic way. To some extent, it just comes down to the personal integrity of the person we elect as the president.
And then finally, we, I'm not in any of these
Yeah.
jobs or anything, but in my very basic civics understanding, you have three branches of government. You know, and the Supreme Court has the final say. But what if the president says, I don't care?
That's an unanswered question, and I hope we don't find that we don't have to answer that question, is what I hope. I hope that we never come to that point. And so far, I will say that on almost everything, he has not defied court orders. There've been a few things where apparently his administration thought maybe they'd get away with it, like not turning the planes back in the Obrego Garcia case, you know, where they thought they could get away with it. But by and large, they have complied with rulings. They have failed to appeal from a surprising number of lower court rulings, where they've lost. And so there is a certain amount of, in fact, I'd say there's a kind of a large amount of compliance going on. And I hope, yes, like you, I hope that will continue.
Penny, we can't thank you enough. Your
Wow.
preparation, your expertise, your response. You are definitely dedicated to the preservation of justice and law. We really, really appreciate this. For those of you that, yes. I didn't receive the handout, I had put in the chat, but my email is carrstarr@gh.com. I will send you a copy of the handout. And we have several weeks of more really inspirational programs ahead. Next week, in case what you've been hearing and experienced yesterday, today, spur some troubling dreams or any kind of dreams. We have an experienced pastor who has led his folks in many congregations to look at our dreams as a very important aspect of our spiritual life. Jeff Nelson, he's written this book, and I've got some copies here of Dreaming in Church. I've been reading it. I got to talk to Jeff. He knows what he's talking about. His leadership is we're so lucky to be having him visit next week. And then the following week, we have Courtney Kennedy Shea, who is the Pew Research expert, and I understand internationally respected expert on the validity of polling and polls, and what will be, she'll be letting us know what we can trust and not trust and what that might be. But in the meantime, thanks so much for being with us. Folks in the room, we could put the chairs up to help the small sacks, but thank you, Penny.
You're welcome.
Yeah, and sing well. Thank you. Thanks, everyone.